ahead.
Good morning to everybody from London, and good afternoon to everybody in India, and evening if you're joining from elsewhere. Thank you for joining us for this webinar today, which has been jointly organized by Wilmer, Hale and J. Sagar Associates. My name is Shanelle, Irani, and I'm a senior associate in Wilmer, Hale's international arbitration practice in London. The topic for today's webinar is an interesting one, the Group of Companies Doctrine, mostly because we try not to bring you boring content. Third parties in international arbitration is a subject of heated debate. This is because, as we all know, arbitration is a creature of consent. And the embodiment of that consent, the arbitration agreement, is of foundational importance to the process. Typically, the parties that are bound by an arbitration agreement and that are considered to have provided consent to arbitrate are its signatories. But like any other contract, non-signatories can also be bound by an arbitration agreement, albeit under limited circumstances. The majority of doctrines that are used to bind non-signatories derive their basis from existing principles of contract, company, and agency law in domestic legal systems. But there is one conspicuous outlier, the Group of Companies Doctrine. With limited exceptions, the Group of Companies Doctrine has received a lukewarm reception in most civil and common law jurisdictions. Breaking ranks with its common law counterparts, Indian courts have displayed a greater proclivity for the Group of Companies Doctrine, though that may be about to change. In this webinar, we will discuss the genesis of the Group of Companies Doctrine, the reception it has received in various jurisdictions, including India, and the recent decisions on the doctrine, which will pave the way for the road ahead. In terms of format for this webinar, we're structuring it as a Q&A discussion. In addition to the questions posed by me, I'm sure that you will also have questions for our panelists. The audience will see a Q&A panel on the right side of your screen, where you can type in your questions during the webinar, and the panelists will answer these in the final 15 minutes. Before I begin, I will introduce our expert panel, who need no introduction, which is exactly what people say before they launch into lengthy introductions, but I will keep this brief. First, we have Gary Vaughn. He is the chair of the international arbitration practice at Wilmer, Cutler, Pickering, Hale, and Dorr, and is widely regarded as the world's preeminent authority on international commercial arbitration and international litigation. He has been ranked for more than 20 years as one of the world's leading international arbitration advocates. Gary has participated as counsel in more than 675 international arbitrations. He has published various leading works on the subject and has received many accolades, which I have to list out individually, we will be here a while. Next, we have Finizio. He is also a partner at Wilmer Hale's international arbitration practice. Steve has particular experience with energy, financial services, shareholder, joint venture, and M&A and manufacturing issues. He has advised clients regarding disputes under the rules of most well-recognized arbitration institutions and governed by the laws of jurisdictions in Europe, Asia, Africa, and the US, as well as under bilateral and regional investment treaties. Steve has been ranked amongst the leading international arbitration lawyers in various legal rankings for a number of years and is also a member of the Legal 500 Hall of Fame. We also have with us today Mr. Farhad Sorabjee, who is a senior partner at J. Sagar Associates. Farhad regularly acts in domestic arbitrations, complex multi-jurisdictional international commercial arbitrations, both institutional and ad hoc. He also regularly advises and acts in investor-state arbitrations and in arbitration-related court proceedings in India. Farhad was the lead advisor in simultaneous litigation and arbitration proceedings in Sri Lanka and the UK for a global port operator for which JSA was awarded Dispute Resolution Asian Council Deal of the Year. Farhad writes and speaks extensively on arbitration and competition law issues. Finally, we have with us Pratik, who is also a partner at J. Sagar Associates. He has represented clients in domestic and international commercial arbitrations, both ad hoc and institutional, and acted in numerous court proceedings in India, both arbitration-related and otherwise. In fact, Pratik recently represented a well-known software company in proceedings before the Indian Supreme Court pertaining to issues relating to the Group of Companies Doctrine, which we will be discussing today. Now, without further ado, if I can just launch into the questions to our expert panel. Let me start with Steve. Steve, before we go into details, for the benefit of the audience, What really is the Group of Companies Doctrine, and what is the genesis of the doctrine?
Shanelle, and hello to everyone. The Group of Companies Doctrine, as I think as you've indicated, is a doctrine that in broad terms finds that a non-signatory to an arbitration agreement may be bound by the arbitration agreement in certain circumstances. And what it focuses on is where a situation where there are, as the name suggests, a group of companies that are connected to each other, where one of those companies may be a signatory to the arbitration agreement and the others aren't. But in analyzing the circumstances, tribunals or courts have found that they act in a sufficient way so that the signature of one of the group companies to the arbitration agreement binds non-signatories. And I'll come back to the genesis in a second, but I want to put that in context because we do see a number of other doctrines in which tribunals and courts have found non-signatories to be bound by arbitration agreements. So it's important to put the Group of Companies Doctrine, I think, in that context. And I'll quickly go through these doctrines, which will be familiar, I think, to most people on here, but will vary in their application depending on the applicable law to the arbitration agreement. And sometimes there are complicated choice of law questions about what law applies to the question of who is bound by an arbitration agreement. But there are doctrines like agency, in which a party may be bound because of the actions of an agent, whether implied or express. Similar doctrines are doctrines of ostensible or apparent authority, which may be used to find that a non-signatory is bound by an arbitration agreement. We have non-signatories who can be bound through assignment or subrogation of contract, including an arbitration agreement. There are various ways in which tribunals and courts have tried to find implied consent to bind non-signatories. And again, this will depend on the applicable law. And I think it's important to also think about doctrines like veil piercing and alter ego, again, in which non-signatories can be bound because a tribunal or court determines that they are actually the party or sufficiently connected to the party that the distinction between them isn't a basis to avoid the agreement to arbitrate. It's also, I think, you sometimes have statutory bases, the Third Party Beneficiary Act in the UK, for example, which can be used to bind non-signatories. And increasingly, we see courts applying the doctrine of estoppel. And it's usually some version of equitable estoppel to find not just that a signatory might be bound in a claim by a non-signatory, which I think was traditionally how it was used, but to find through estoppel that a party has acted in a way in which a non-signatory then gets bound to an arbitration agreement. So the Group of Companies Doctrine, I think, does need to be seen in that broader context of various doctrines that are used to bind non-signatories. And just quickly on the origin, I think that it's generally traced back to a case, an award issued by a tribunal, an ICC case in the Dow Chemical case in 1984, in which the tribunal found that it had jurisdiction over two non-signatory companies in the Dow Chemicals group because they were part of the same group as the signatory parties, because they had taken an active role in concluding, performing, and terminating the agreements that were in dispute. And then the tribunal found that, looking at the facts, that there was a common intention among all the parties to bind those companies or treat those companies as one unit. So that's I think the origin, and we see a number of courts, particularly in civil law jurisdictions, that have followed, and tribunals as well, who have followed that doctrine. It is controversial, and I think we're going to go on to talk about the fact that courts and tribunals in other jurisdictions have been less enamored of it. In some jurisdictions, there have been decisions rejecting the doctrine as expressed in those terms, but query whether or not some of those courts and tribunals might get to similar outcomes using those other doctrines that I just walked through quickly.
Thank you, Steve. Gary, just picking up on that, apart from France, the Group of Companies Doctrine has received a lukewarm reception in most major jurisdictions. Why is that, in your opinion?
Shanelle, you're certainly right that the Group of Companies Doctrine, at least when you use that name, has received at very best mixed reception, lukewarm reception. It's worth looking at a couple of examples because, as international arbitration practitioners, I'm sure that participants will have arbitrations in many different jurisdictions and under many different laws. The English courts are perhaps most famously known for their fairly explicit rejection of the Group of Companies Doctrine. Is a well-known case, decade and a half old Peterson Farms, where an arbitral tribunal applied the group of companies doctrine, looking to the French authorities that Steve mentioned, Dow Chemical and other awards, as well as French judicial decisions picking up on that theory, the group of companies theory. The English court had no difficulty dismissing the group of companies theory. It said that it held that the group of companies doctrine is no part of English law. And given that it also concluded that English law was applicable to the arbitration agreement, it set aside the award. That reception has been followed by other English courts and commentators. The basic mantra, rationale that one hears in those decisions is that the doctrine of separate corporate identity is inconsistent with the group of companies theory, that parties are permitted, arguably encouraged, to set up separate corporate entities which not only have their own distinct legal identity but have limited liability. The whole point of a company is to protect the shareholders from unlimited liability for the company's obligations and debts. And the English courts emphatically embraced that notion in rejecting the group of companies doctrine. Singapore courts, perhaps unsurprisingly, did much the same thing. The case Manichar Steel similarly involved the rejection of something that was quite like the group of companies doctrine. Tribunal had relied upon the notion that a group of affiliated companies with common ownership and other attributes of being part of a corporate group were part of a single economic unit or entity. The Singapore court rejected that notion, concluding that, like the English courts, the principle of separate, distinct corporate identity and limited liability had to be respected. U.S. courts have been less explicit in addressing the issue, but at least indirectly have suggested that they too would, if squarely presented with the question, reject the group of companies doctrine. I think this is more a question of debate than either in England or Singapore, and it might vary from one court of appeals to another. But in a well-known case, Sarhank versus Oracle Corporation, the Court of Appeals emphasized that there were only a limited number of common law doctrines for binding a non-signatory to an arbitration agreement. It referred to the doctrines then that Steve had mentioned, alter ego assignment, agency, and the like. Conspicuously missing from that list was anything like the group of companies doctrine, and then the court, perhaps unsurprisingly, again underscored what the English and the Singapore courts had said with respect to the basic point of limited corporate liability. All that said, I think if one digs a little bit deeper, one sees at least the possibility, both in the United States, in Canada, elsewhere, of something like the group of companies doctrine. It may be that name is too freighted with controversy these days to be embraced explicitly, but in the United States, a number of courts have upheld the notion that a corporate officer or corporate director can invoke an arbitration agreement if he or she is sued on a dispute where the company of which they're an officer or a director is bound by an arbitration agreement. So the basic notion is company A contracts with company B, there's an arbitration agreement, company B sues company A, and to avoid the arbitration agreement, also sues Company A's directors and officers, or at least some of them in their personal capacity, and says, we don't have an arbitration agreement with those individuals. But in that litigation, seeks to litigate basically what the dispute that would be arbitrated is. U.S. courts, also Canadian courts, have in those circumstances permitted very frequently the individual officer or director to invoke the arbitration agreement. It's not on all fours with the group of companies theory, but it's important in that it reflects how U.S. courts, some other courts, look to the arbitration agreement as a separate, obviously autonomous agreement, and try to give it effects that make the arbitral process work better, and that must have been in the contemplation, even if not explicit, of the parties to the underlying transaction. How exactly that maps onto the group of companies doctrine isn't necessarily straightforward, but I think that announcements that the group of companies doctrine is dead outside France and as I think we're going to hear, India, are perhaps premature. There certainly are lukewarm negative indications, but I think there are also other tendencies, other trends that might suggest, perhaps with a different name, a more receptive greeting.
Thank you, Gary. Pratik, so picking up on what Gary just said, let's talk about for a minute the group of companies, at least in the traditional sense of what it was considered to be. India has broken ranks, like I said in my introduction, with its common law counterparts and applied the group of companies doctrine. And we're going to come to how Indian courts are reconsidering this. But before we get there, can you tell us how Indian courts have dealt with the doctrine previously?
Thank you, Shanelle. So picking up from what Steve and Gary have said, yes, the doctrine has been controversial, but in my view, to an extent, it has found support in the Indian arbitration scene. It appears to have been embedded in Indian arbitration, at least so far. So like any other arbitral laws, the Indian arbitration also does not particularly expressly recognize the doctrine of group of companies. So while dealing with cases of dealing with the concept of group of companies, what the Indian courts have found assistance in, or they've justified the usage of this doctrine based on a phrase which is party or any person claiming under through such party, which appears in section 8 now, 35 and 45 of the Indian Arbitration Act. India really, as far as India is concerned, the first case, the opportunity which the division bench of the Supreme Court had was in the year 2003 in the Sukanya Holdings matter. It first time dealt with the principle of group of companies doctrine. And in that matter, particularly, the Supreme Court held that the cause of action, if not related to the arbitration agreement, if it is not a matter related to the arbitration agreement, there cannot be bifurcation of the cause of action, and arbitration should be restricted only to the parties who are signatories to the arbitration agreement. After Sukanya Holdings in the year 2010, the Supreme Court, again, yet another opportunity for the Supreme Court was in the matter of Indowind, where the court particularly placed reliance on Section 7, which defines the arbitration agreement as a written form of agreement where parties agree to submit their disputes arising out of the contract to arbitration. And in that particular matter, the Supreme Court again rejected to apply this doctrine, so as to say, and it held that only the parties to an arbitration agreement, the signatories, can be a part of the arbitration. And also, even if the company has common shareholders or directors, that does not matter. So up to 2010, the Indian courts have adopted a very restrictive approach. They upheld the principles of party autonomy and privity of contract, so as to say. A decade later, after the Sukanya matter, in around 2013, the doctrine for the first time was recognized in India in the matter of chloro control. In the matter of chloro control, the court has held that this group of doctrine can be applied where the intention of the parties is very clear to bind the non-signatories to an arbitration agreement. And it laid down the 5 tests. If I can briefly summarize the 5-pointer test that the Supreme Court laid down in the chloro control matter, it says the group of company doctrine can be used in exceptional circumstances where where it is based on the touchstone of the mutual intent of the parties, the relationship of a non-signatory to a party, which is a signatory to the agreement, the commonality of the subject matter, the composite nature of transaction, and the performance of the contract. So based on the reading of the Supreme Court in this particular matter, it paved way for the usage of the doctrine in other subsequent matters like Amit Lalchan, ONJC discovery, Charan Properties, and particularly in a matter of Mahanagar Telephone versus Canara Bank, where the Supreme Court also held that this doctrine will also apply where there is a tight group structure with strong organizational and financial links, where the concept of single economic entity comes into play. So far, just before the SAP judgment, I see that the Indian arbitration supports this doctrine.
Thank you, Pratik. Farhad, if I can turn to you for a minute. As Pratik just said, the Indian Supreme Court has paved the way for the application of the group of companies doctrine through the use of the phrase party claiming through or under. But there still remain certain provisions such as Section 11 in the Indian Arbitration Act and also the definition of party, which has not been amended to include this phrase. So how does one reconcile these differences in the legislation in the context of the group of companies doctrine? I think this one is specific to our Indian attendees.
Yeah, hello, everybody. Yes, that's an interesting question because if you look at the actual statute, the law, it has many references to this concept of a person claiming through or under. In section 45, where courts can direct on an application by a non-signatory that the parties should arbitrate. Then there's 35, there's 54, there's 73, and now there's 8 after the amendment. But I think what's important is that we should also remember that all these provisions suggest that there is some sort of distinction between a non-signatory, a party claiming through, and who has to actually arbitrate, because it keeps referring to, it can ask for direction to the parties arbitrate. Now, that party's definition has not been amended to mean anything other than the parties to the contract, which is where the problem arises. So there is, really speaking, a certain, well, at best you can call it, it's divergent, but there are certain contradictions. And when you have these handles in the law, sooner or later, someone is going to turn the handle and walk through the door, which is what chloro controls did. And basically said, and I'm not sure that it hasn't stretched section 45, and said that we can look at everything and look at the holistic approach to how they should be treated. Now, I think that there is something to that, because what we are dealing with here is a classic legal dilemma between concepts of equity and common sense and the black letter of the law. It's that simple. And it is somewhat muddied at the moment in terms of what the actual law says, as a result of which you have this progression of judgments that India has in fact been going through, and we'll come to that later, where what's happened thereafter, the proposed amendments.
Thank you, Farhad. Steve, so India isn't the only country whose Arbitration Act contains the phrase claiming through or under. Can you tell us how courts in other countries have interpreted this phrase generally and specifically in the context of the group of companies doctrine?
Sure. I think that unlike India, other countries, the courts have not turned the handle, to use Farhad's phrase. While we see similar language, for example, in the English Arbitration Act, the Australian Arbitration Act, the Singapore Arbitration Act, I think it's generally been seen to mean something more specific, which usually is something that binds a party or allows a party to be sent to arbitration where that party is stepping into rights or obligations of signatory. So it really is read more literally in terms of the phrasing through. It's also obviously claiming through, and so that takes away one aspect of the way these doctrines in the group of companies doctrines has been used, where a claimant is trying to bring non-signatory respondents in. It limits the circumstance to a situation where a party initiates a court proceeding, and then the respondent says, no, you're bound by an arbitration agreement, even though you are not a signatory, and then you make the argument potentially that that party is claiming through. So it's been read in very limited ways, and to be really quick about it, because I think we've got more interesting things to talk about. The Australian courts, I think, have rejected that idea in a number of cases, limiting it to the idea that it is where a party is bringing a derivative type of action through the rights and enforcing the rights of the signatory. English courts have taken the same approach and have rejected the idea that it expands jurisdiction. And we see that in a couple of cases, including recently in Neighbor Global, in which the court said that a holding company that was bringing a claim that was related to a contract that its subsidiary had with a law firm couldn't be bound to arbitrate through this idea of claiming through. And the Singapore courts have done the same thing, and they've rejected using that phrase to expand the idea of the ability to refer a party to arbitration through that language in the statute. So I think generally the other courts in jurisdictions that do have that language have not used it to get us into a sort of a de facto group of companies application.
Thank you, Steve. Farhad, if I can come back to you once more. We've been discussing this change of track by the Indian courts. Can you tell us more about the recent developments in India connected to the group of companies doctrine, and obviously with the caveat that GSA appeared in the matter, and so you can't speak beyond the point about it?
Yeah, sure. So you had this watershed moment of chlorocontrol, which is, I mean, sort of said that we're walking through this door and we're going to do with this and expand things. And I'm not saying they were right or wrong. They could well be a good case made out on either side. But then there was a suggested amendment, which ultimately went through in a watered down way. It was the Law Commission that made a recommendation, and then ultimately amendments were made in 2015, which brought in some more of the persons claiming through in, say, Section 8, but still didn't amend the definition of parties. So you still had this slightly sort of ambiguous situation. After that judgment, what has changed? Not a lot initially. Basically, there were several judgments, two of them stand out, which symbolize the same approach as in chlorocontrols. One is Charon, which went into things like you have to look at the circumstances, you have to look at the commonality of the entities, you have to look at the true essence of the contract. The alter ego was, which Gary has mentioned, was often quoted in many of the judgments, and basically adopted that practical approach regarding non-signatories. Then there was, I mean, Rekit Benkisar. There were a lot of judgments which pretty much followed the same line as chlorocontrol. In 2022, we come to two one judgment and one order really, which one was in discovery, which reiterated almost in toto chlorocontrol. and all the previous judgments going in a particular direction. And then you had the order of reference to a larger bench in Cox and Kings and SAP. As I said, as you mentioned, there's a disclaimer here. We can't really talk about that matter in any great detail, but we can talk about what's in the public arena, which is the order of the court referring it to a larger bench. It makes several points. It says that the doctrine has been utilized in a varied manner, which is interesting because the doctrine has been, in that sense, used in a varied manner, but has been used consistently. I mean, in varied manners is one thing. Then there is the rationality of the doctrine needs to be examined, is what they said. It emphasizes, of course, the importance of party autonomy. It also seeks to distinguish Dow by saying in that case it was the non-signatory itself who made the application. It leaves a certain door open by saying that there is a heavy onus to show that a party is claiming through. So it doesn't quite say that you can't do it, or we don't agree that it can never be done. It says there is a very heavy onus. And it then, of course, says that the definition of party is clear, and it remains unamended in that sense. So in that sense, that is what it basically says, that order. It says that it must be applied with caution. And I think that India, in that sense, is a country where the courts are keen on being proactive. They're keen on applying common sense. And it's a question of whether you want to be just practical or whether you want to actually call it a specific prescribed doctrine. I think that's another area which is a bit blurred as to how you want to treat it.
Thank you, Farhad. Pratik, stepping away from the Cox and Kings judgment for a minute, how do you think that Indian courts are likely to treat an award where the group of companies doctrine has been employed to bind a non-signatory? What sort of issues do you think would arise?
Before I get on to answering this question, it would be important to note over here that the group of companies doctrine was relied upon by the Supreme Court in the post-Chloro era in Cheran properties, like Farhad just mentioned. And in particular, this was relating to the interpreted section 35. Again, section 35 has similar language, which says the award is binding on parties and persons claiming under them. So using this phrase, the court actually allowed enforcement proceedings, the award to be enforced against a party which was not a party to the arbitration itself. So it was a third party, non-signatory, did not participate in the arbitration proceedings, but had an order from the Supreme Court enforcing the award against such a party. So having said that, apart from that one judgment, I do not recall any other judgment which deals with this group of companies doctrine as far as enforcement of an award is concerned. Now, if the courts are likely to use it going ahead, it would lead to protracted proceedings, because obviously, like we've seen in prior judgments also, the party against whom this doctrine is used is bound to challenge the award, though the Indian Arbitration Act provides for very limited grounds to challenge an award. But having said that, I would say that this would give an opportunity to the party to challenge the award for the appellate, and then this leads to protracted proceedings. But one will have to see what the Indian courts ultimately go on to do. It will largely depend upon what the Supreme Court holds in the Cox and Kings and SAP matter, which is pending hearing before the Constitutional Bench.
Thank you. Before I turn to Gary, I just want to remind the audience that if you do have any questions, please please type them into the Q&A panel on the right-hand side of your screen. Though I'm sure the panelists are doing an excellent job explaining the doctrine and its consequences, but we'd like to hear from you too. Gary, are the issues with the group of companies doctrine arguably just one of semantics? Isn't the doctrine just a manifestation of the principle of implied consent?
There is a lot. There's a lot to that observation. I think in some circumstances, especially if you go back to the original Dow Chemical Award and some of the early both awards and French court decisions applying the group of companies doctrine, there was a very pronounced emphasis on consent, and in particular, as you say, implied consent. You were necessarily in a world of implied, not expressed consent, because you were dealing with non-signatories, people who had chosen, not companies that had chosen not to sign the arbitration agreement. And the underlying contracts, the arbitration agreements, didn't have any express language that suggested something to the contrary. The basic concept of the group of companies theory at that point, though, was if you look at a number of external factors, if you look at the common ownership, if you look at common names, logo, branding, many of the factors that one would look at in an alter ego analysis. And if you look at how the parties performed the underlying contract, from those things, one could conclude that the non-signatories had impliedly consented to be bound, and on the other side of the coin, the counterparties, the signatory counterparties had in turn impliedly consented to accept the non-signatories as parties to the arbitration agreement. There was, put simply, a distinct focus on the parties' intentions, and in particular, implied consent to the arbitration agreement. I think in subsequent cases, the group of companies doctrine was at least sometimes expanded in a much broader fashion, dropping the second inquiry that I referred to, namely, what were the parties' intentions here, and focusing instead on, if I can put it this way, an alter ego light version of the factors, the objective factors such as common ownership, being part of a single corporate group, single economic entity, and so forth. I think that if arbitral tribunals, if courts were confronted with a greater emphasis on implied consent, and most importantly, implied consent to the agreement to arbitrate, not the underlying contracts, the reception would be less lukewarm, less chilly. Obviously, establishing implied consent where sophisticated parties have contracted in a particular way isn't straightforward. It may be, as we've heard the English courts require, an exceptional showing, but perhaps not as exceptional as is required for piercing the corporate veil for alter ego. I think the fundamental question, and I don't think this is one of semantics, is have parties which contracted to arbitrate their disputes, impliedly intended that closely related parties on both sides be bound by the arbitration agreement to arbitrate essentially the same dispute, or did they intend that the arbitration agreement would sit in a sea of litigation, even if that was exceptionally inefficient, costly, and contrary to the basic purposes of the arbitration agreement. I think focused on that issue, the group of companies doctrine perhaps with a somewhat different name, has more legs than the English and Singapore courts would lead us to believe.
Thank you, Gary. Farhad, Gary and Steve have both touched upon the other legal basis, or the legal basis other than the group of companies doctrine that could be used to bind a non-signatory. Are those the same that courts in India would use to bind a non-signatory to an arbitration agreement, or is there any difference with, say, the UK or Singapore?
Yes, so before we get to that, just one point which struck me, which Pratik also touched upon, which we should remember, is that Cox and Kings is not a judgment. It is an order referring a matter for consideration with points, with questions of law to a larger bench of the court. So as of today, there is no stay on the operation of the law as it has developed so far. And that rests, really speaking, with discovery. So that's one thing which we need to be clear about. So regarding the legal basis, look, our law has developed largely in tandem with English law and with Commonwealth law, and now increasingly turns to US law as well. So call it what you like. There are ancient concepts that afford non-signatories protection and involvement and inclusion in the consequences of such proceedings. If you look at the judgment in Cherian, that in fact specifically mentions things like it mentions the corporate where, it mentions alter ego and goes into great detail on alter ego. It mentions principal and agent. It mentions successors in title. It mentions assignees of rights. And these are all concepts that are really well established in Indian law and in our statutes. So it's not as though these are new concepts or that they're concepts which have been brought in because of this issue with arbitration law. Our Companies Act has several provisions and detailed explanations of what constitutes control of another entity. So certainly there is a strong basis in all these concepts that we mentioned, which have been around for ages and in Indian law and are actually pretty much visceral components of our law. So it's not as though that's gonna change. That's gonna continue, and that will continue to hold sway, irrespective of whether you call it as we've been discussing, whether you call it a doctrine or whether you call what's been happening so far a cumulative doctrine being put together, despite the fact that the code and the law in itself doesn't mention it per se. So that's where we stand. So these are all not concepts which are new, and they will continue.
Thank you, Farhad. Steve, in your view, what is the best way for parties to avoid the application or the misuse of the application of the group of companies doctrine, which is, and the misuse is obviously what a lot of commentators have written about and have an issue with?
Look, I want to slightly reframe the question. I think the question is, how can parties take better control of the predictability and efficiency of the arrangements, particularly when you're talking about related contracts or related companies who are, because we see that these issues arise very often in contracts where there may be multiple entities within a corporate family who are involved in a supply chain contract or a construction contract or some other project which involves multiple transactions, arguably in multiple contracts. And the question is, are the parties thinking thoughtfully about how those different contracts and those different entities interrelate and how disputes between them should be managed? And I think, frankly, very often they're not. And you have a hodgepodge of dispute resolution mechanisms, a lack of thought that goes to how those different contracts and those different parties relate to each other, particularly when something goes wrong. And so Gary talked about the appeal of these doctrines sometimes being the question of efficiency, and what would the parties really want if they could step back now when a dispute has arisen and do this. So parties do need to take control of and think about the relationship between the contracts and the parties. And that also means thinking about the use of joinder and consolidation provisions in arbitration agreements as well to create efficiency. But if a party really wants to create some greater predictability about the risk of the group of companies doctrine applying, there are certain specific steps that they can take. I'm going to caveat that by picking up on what Farhad just said, though. We rarely see the group of companies doctrine being the only basis that a party seeking to bring a non-signatory into a dispute invokes. It's usually one of a number of grounds: alter ego, agency, veil piercing, estoppel. All these different doctrines get all thrown out there. So you need to be thinking about how to manage all those risks. One way to start to control the risk is to consider subjecting the arbitration agreement specifically to a substantive law. So the law of the arbitration agreements being specified in the contract, and thinking about choosing a jurisdiction which is less receptive to the group of companies doctrine if you're trying to manage that particular risk. But again, thinking also about these other doctrines, because you don't want to jump out of the frying pan into the fire, depending on the jurisdiction you pick, then you are increasing the chances you may find an alter ego or estoppel ruling that brings a non-signatory in. But we've talked about England and Singapore being jurisdictions that have been skeptical of the group of companies doctrine. So one thing you could think about is being express about subjecting the arbitration agreement to the law of that jurisdiction. You can think about the seat of arbitration. And I do think it's often said that it's really the law of the arbitration agreement. In my experience, it's actually a mess. And therefore parties, and particularly when you're talking about all these different doctrines, parties will argue about the applicable law and look at lots of different potential applicable laws, including when there's a non-signatory. Can you apply the law to the arbitration agreement to the non-signatory, and what law applies? But you can multiply the safeguards by also choosing a seat, I think, that is less receptive to the group of companies doctrine. And we know that the Indian Supreme Court has now made clear that Indian parties can seat arbitrations outside of India. That's PASL, Wind Solutions, and other cases. So we that may be an option. I think practically, and we've been talking about this throughout, it's the behavior of the parties that often is the genesis for these arguments. So if you have other parties in a corporate group, making sure that you think about their participation in the rights that arise under the contract with the arbitration agreement. Are they participating in negotiations? Are they participating in performance? If you want to avoid that risk, one thing to do is to make sure you're minding those corporate distinctions by also the way you manage the relationships between the parties in practice. You can expressly try to put in phrases into your arbitration agreement saying that this agreement only binds these parties and no one else, and also any remedies can only be found against the signatory party. You can try to contract for that. And there are other contractual things you can do. Parties often argue about entire agreement language or oral modification language to say that means you can't include other parties. That's not always that effective, but there are things you can do. And then, of course, if you're in a situation, whether or not you've tried to do that through your contractual and performance mechanisms, if you are a non-signatory in a chain of transactions or where there are multiple parties, including some that have arbitration agreements against them, and you're bringing a claim in court, you may want to be careful about how you characterize your claim to try to separate it and show that it's independent and separate from the rights and obligations that arise under the contract that has the arbitration agreement. So there's various ways you can try to control the risk, but there are ways to control the risk. And I'm going to come back to say this shouldn't be a scramble. Parties need to think more when they create these sorts of contractual relationships about how to do this efficiently, to make sure that they're actually doing it smartly and not just managing risk, and maybe taking advantage sometimes of the efficiencies you can get by having a thoughtful dispute resolution mechanism that runs across multiple parties and multiple contracts.
Thanks, Steve. All practical, useful tips. So we're coming up on the hour, and I'm going to give Gary the last word. And that also means that this is the last 5 minutes that the attendees have to ask any questions. Gary, how do you see the doctrine developing in the future?
Being asked to predict the future, especially across multiple jurisdictions. I think I think there's a core truth to the group of companies doctrine, which is not fundamentally different, at least in its objective, to some of the other long-standing, well-established doctrines for binding non-signatories. Alter ego, apparent authority or ostensible authority operate without regard to the parties' consent. They are based on principles of equity and fairness, which in limited exceptional circumstances can override even contractual provisions like Steve outlined, and certainly can overlay the express terms of contracts that only bind some signatories and not other non-signatories. And in those circumstances, alter ego, apparent authority are readily applied to bind a non-signatory. The same is true for estoppel, which we haven't discussed much, but which is not infrequently applied, including again by some of the very U.S. courts that seem to reject at least versions of the group of companies doctrine. There's expansive notions of direct benefits estoppel, which can bind non-signatories. And I think that whatever it's called, a doctrine that focuses on the relationship between signatories and non-signatories, the course of performance of an individual transaction, and the presumed intention of parties to resolve their disputes in an efficient and enforceable manner without the delays and disputes of national court litigation. All those objectives, it seems to me, one way or the other, find their way into the interpretation and application of arbitration agreements. And the group of companies doctrine has probably managed to incur too much common law wrath and antipathy to have much of a career going forward. But the results produced by the group of companies doctrine and the considerations that it requires taking into account, I think, do have a lot more longevity than the group of companies doctrine itself. I wouldn't pronounce even so named the group of companies doctrine dead. I'm sure the French won't give it up without a fight. It sounds as if in India it still has at least some life, and who knows in other countries. But whether or not the group of companies doctrine survives in all 170 contracting states to the New York Convention, the considerations that it takes into account with respect to implied consent and the efficiency of the arbitral process, I think, will have application under some doctrine.
Thank you, Gary. So I think we've been very good on time. We're 1 minute under the prescribed time. And I see that our panelists have done an excellent job with explaining the group of companies doctrine. So we haven't received any questions yet, but I'm going to extend an invite to everybody who has attended, that if you do have any questions that you think about later, please feel free to email us, and we'd be happy to answer by email or even get up to a call to discuss the issues. So that leaves me to thank all the panelists for taking the time to answer my questions today. And thank you, of course, to everybody who has taken the time to join. And wish you all a very happy rest of the day. Thank you.